And good morning, everyone. This public hearing is conducted by the Committee on Land, Environment, Housing, Agriculture, Parks, and Infrastructure. It's called to order at 9 o'clock a.m. Today's date is Tuesday, February 18, 2025. Notice of today's hearing was disseminated to all local media outlets on February 11, 2025, with a second notice provided on February 16, 2025. Notice of the hearing was also made known on the Guam Legislature's website and the Government of Guam Public Notice Portal. This morning, the committee will hear testimony on Bill 5738 COR, an act to strengthen housing options by adding a new sub-Article 3 to Article 1 of Chapter 61, Title 21, Guam Code Annotated, relative to authorizing the construction of accessory dwelling units, ADUs, in residential zones. Introduced by Vice Chair Senator Chris Dueñas and co-sponsored by me, Senator Tina Munoz-Barnes, Speaker Frank Blas Jr., Senators Vincent Borja, Shelly Calvo, Gumataotao, Sabrina, Salas, Matanane, Will Parkinson, and Agustin. This afternoon, we will also be hearing testimony on the appointment of Mr. Gerald P. Yingling as a member of the Guam Land Use Commission for a term of 5 years from the date of confirmation. I would like now to welcome my colleagues and thank them for joining us today. To my right, we've got the Vice Chair, Senator Dueñas, Senator Gumataotao, Senator Terlahi, thank you, ma'am, Senator Lujan, Senator Calvo, Senator Taitagui, and Senator Matanane. Thank you all for being here again. Before we begin, I'd like to go over the general rules of conduct. Individuals testifying shall first be recognized by the chair before speaking and shall state their name for the record-keeping purposes. Questions and testimony shall be confined to the substance or nature of the agenda. Personal interference as to the character or motive of any senator or any individual testifying is not permitted. The chairperson of the committee may order the removal of from the hearing any member of the legislature in Guam who fails to observe proper decorum pursuant to the 38 Guam Legislature standing rules. Any violation of this general rule of conduct will result in the removal from the hearing. We will now proceed with hearing on testimonies for Bill number 5738 COR, and I'd like to invite the Vice Chair and the author of the legislation to introduce his bill. Thank you.
Sidus Masi, Mr. Chairman, and welcome to everyone to this public hearing this morning on Bill 5738. It is an act to strengthen housing options by adding a new sub-Article 3 to Article 1 of Chapter 61, Title 21, Guam Code Annotated, relative to authorizing the construction of accessory dwelling units, ADUs, in residential zones. This is authored by myself and co-sponsored by Senator Ada, Senator Lujan, Senator Munoz-Barnes, Senator Speaker Blas, Senator Borja, Senator Shelly Vargas Calvo, Senator Gumataotao, Senator Sabrina Salas Matanane, Senator Parkinson, and Senator Joe S. and Agustin. Mr. Chair, this bill was formerly Bill 2838 and now has become 5738 as a result of a really nicely put together housing summit by GURA, and I would like to welcome former Senator Fernando Esteves and now the Deputy Director of GURA. Some modifications were done to this bill in order to make sure that it was clear that what we're calling for here on these ADUs is a permitted use as opposed to a conditional use in order to facilitate ease and also non-cumbersome governmental operations when it's a permitted use with all the restrictions in place of the Code of Guam in terms of our codes that regulate how we have to construct and what we need to do to be able to construct these structures. Mr. Chairman, my opening statement goes as follows. To those that are here, I think most of you already realize and know what I'm about to say. To those who are watching us on TV, this declaration will not come as a surprise to you. Ladies and gentlemen, Guam is in the midst of a housing crisis. That is not hyperbole. That is not an overstatement. That is an actual fact. And that fact has been enumerated by no less than our Department of Defense and our premier housing institution, which is GURA, as well as Guam Housing Corporation. Only a few days ago, the chairman and I invited the Guam Housing Corporation in to speak about some of their efforts and their endeavors going forward. And they fully concur that not only do we have a housing crisis, but we have a regulatory crisis in terms of some of our operations that we can ease this crisis moving forward. If you tonight or this afternoon will go home and be in a home that is secure, that can protect you from a storm, that you can comfortably sleep with your family on Guam, you are living in luxury. Thousands of our people and their families, those who were in the workforce, getting a middle income and some a middle and high income, have relocated off of Guam for the simple reason that they cannot afford the cost of living. At the top of the list is housing. This bill is a hybrid of successful jurisdictions who have ADUs with high regulatory laws on the books, the state of Hawaii and the state of California. This bill has safeguards in it to ensure that we protect our environment, our water, and make sure that adequate power and other regulatory issues are addressed. In the bill, on Section 10, under 61144, it states on Section 10, at the time of the application for construction permit, the applicant shall first obtain written confirmation from the responsible agencies, including Guam Water Works Authority, Guam Environmental Protection Agency, and the Department of Public Works, that wastewater treatment and disposal, water supply, and access to roadways are adequate to accommodate the accessory dwelling units. In another section, under Section 5, under 61145, it clearly states, upon completion of an ADU, the head of household shall inform the mayor of affected municipality to facilitate better governance through safety, community planning, through village population data tracking and compliance. Going back to enumerated 13 under 61144, excuse me, the Department of Land Management and the Department of Public Works must notify upon removal of accessory dwelling units in the case that they may do such a thing. Another area in the bill, under the same section, Section D, lots where existing septic tank sizes are not adequate for the additional footprint, meaning that they must, the property owners or persons who are related, or excuse me, that's a different section, they must have adequate facilities or upgrade their septic systems if they are over the northern aquifer and they are in a situation whereby they're not connected to sewer or don't have sewer available. This bill, simply put, is one small solution in the grand scheme of Guam's housing crisis. In order to stop the bleeding of our people leaving island because they have no hope, not even a dream at this time, of experiencing home ownership, we must at least provide this opportunity so that individuals and families can have the dignity of living in a structure adjacent to their loved ones, whereby they have the dignity of a separate facility, that they can also be in the confines, maybe with their children, have an adequate kitchen facility, have a restroom facility, and be able to live separate and apart, but right next to one another. The last thing I wanted to mention, and I want to thank my friend Troy Torres from Candid for making this comment in his review of this bill, because it was very eye-opening. You know, one of the things we have with our homeless situation is a lot of times we have people who are in crisis. We have people who need treatment. We have families who have given up on trying to help those individuals, but still may see some hope in the rehabilitation of those individuals. For various reasons, they may want to bring those people back, their family members, their loved ones, back into the fold. But this opportunity may provide for peace of mind and independent living for those who may be rehoused on the same property and trying to rebuild their lives. With the homelessness, the drug epidemic, and the housing crisis that we have, this is but one additional opportunity for many of us who have lost trust with our family members, but may be able to rebuild it through allowing them to stay in an additional dwelling unit while maintaining the security and sanctity of our immediate family who live in the main home. With that, Mr. Chairman, I look forward to the testimony on this bill. As I said, there are many safeguards in this bill. If we have to strengthen it more, I look forward to the committee markups. But I think it's a well-written bill. And Mr. Chairman, I want to thank you for leading the charge in the 36th Guam legislature. I was tempted to name this bill the third time is a charm act of 2025, but I was afraid of cursing it. So we have the title as is. Mr. Chairman, with that, I yield to those who have taken time out of their busy schedules to come forward and testify on this bill.
Thank you, Vice Chair. I would first like to recognize my colleague, Senator Chris Barnett, for joining us. Thank you, sir. And also former Senators Tony Lamarena and former Senators Fernando Esteves. Thank you for being here. For those who would like to join, do the oral testimony, I please call you up to the panel. Mr. Tejo, please come forward. Former Senator Lamarena. Director Esteves, please. And anyone else who would like to give written testimony, we have a couple of open seats there. You would like to come forward? Mr. John Dueñas, Mr. Joe Borja, please. You can go ahead and come forward, sir. Thank you, gentlemen, for coming forward and to provide your oral testimony. I'd like to start with former Senator Lamarena. If you can go ahead and start your testimony, and then we'll go down the line.
Thank you, Mr. Chairman. Tony Etta of the Committee on Land, and to all the senators present. It's nice to see almost the full slate of senators present at today's hearing. I'm here to testify. My name is Tony Lamarena. I'm here to testify in favor of the bill. This bill is a long time coming. First introduced by Senator Tony Etta in the 36th Guam legislature, and here we are again 4 years later and addressing the same issues. Sadly, we've cost our people a lot of money. Construction cost 4 years ago was around $150 a square foot. Today, well over $200 a square foot. So even individuals who are going to reap the benefits of this bill, if passed, will still bear that burden of paying more per square footage. That's why you need to act quickly on this piece of legislation to avoid any other further burden on our people. Is the bill needed? Yes. We see it. DOE, prior to the pandemic, had 32,000 students enrolled in our schools. Today, 24,000 students. We're thinking of consolidating schools, shutting schools down. Where did those students go? Mom and dad left. Mom and dad left. The 2020 census was a telltale sign. Negative growth in the 2020 census. Normally, In a 10-year census, you have at least a 4% growth, negative growth. Where did they go? They're leaving island. Power bills, cost of living on Guam is expensive. People are leaving. United Airlines, a couple of years ago, hired almost 1,000 of our people, and they're gone. They're leaving. It's a responsibility of this government to ensure that Guam remains affordable, and housing, the primary cornerstone of living, is a home. We see a lot of multi-generational living here on Guam. You know, you got 2 or 3 families living in one home, one family in one bedroom, another family in another bedroom, one kitchen. And it's you know, the situation we've put our people in is not acceptable. And I'm glad this piece of legislation is back up. And you know, whatever the politics was 4 years ago, you got to put it aside. And you got to think of the people of Guam. You've got to think of the people of Guam. Like I said, you've already cost them a lot of money because the cost of construction has gone up tremendously since this bill was first introduced by Senator Ada. The bill mirrors that of the Ohana legislation in Hawaii. In Hawaii, it's very common to drive around, you see this huge house, but in reality, if you go into the homes, it's 2 or 3 families separated, but it looks like one single home. It's nothing new. As Senator Dueñas said, California does the same thing, and we can do it here on Guam. The median price home right now, according to the last stats I saw, $450,000. If you own no property, that means a financial institution will require you to a 20% down payment of $90,000. Who's got $90,000 in the bank? If you own property, you can use that as equity for the down payment. But who's got $90,000? I mean, that's the reality of the economy here on the island. Our economy is so lopsided. You know, the government of Guam, oh yeah, we've got surplus of $100 million, but our economy is lopsided. The military is primarily the only economy on the island. Our tourism economy is gone. But yet, you know, the government, $100 million, $200 million in surplus, but yet one side of the economy is reaping the riches and the other side of the economy is in the poorhouse. We need to balance that. We need to balance that. Again, the ADU is very similar to that of Hawaii. I do have some recommendations. One is I'm not totally in favor. I'm not in favor of the 4-foot setback. I think that's too close. I think we need to widen that a bit. There needs to be some sense of privacy from house to house. The other one is because some homes don't meet the land requirement, so therefore would not be able to build an ADU, I think the bill needs to also address the possibility of going up, going a second floor, okay? And you see that a lot in Hawaii. The land is not sufficient to build an additional ADU on the property. So you need to allow them to go up. And you know, you can do that if the house is load bearing, or engineers can actually make the home load bearing so they can actually build up. In Hawaii also you see a lot of ADUs, not necessarily just one unit, actually there's several units on the property. And I think you should allow that too as well. As long as they meet the necessary land setbacks and the height variances and so forth. So if they have the land to build one unit and then they can build on top, allow them to do that. If they can build 2 units, they've got 2 or 3 kids with families that need homes. It's not uncommon here on Guam. And so rather than just allowing them just one unit, you know, if they meet the requirements of going up And then they meet also the requirements of building an attached unit, then allow them to do that as well. And then the other one was, hold on, because I just wrote my notes down. You know, I'm retired, so I don't have time to get on a computer and write a testimony, so yeah, so again, I think the bill also, Senator, is that it only allows for, I think, it only mentions one unit. I don't know if the intention was just for them to build one unit, but I think the language needs to be addressed that allows them to build several units if permitted via land area and by also building up. Because if they can build 2 units so they can have 2 of their children living on the property, or even 3 units, that's fine. The big problem Hawaii had when they started the ADUs was that the intention was for family to live in it. But once family moved on, they moved off island, or they built their own home, or they bought their own home, they became more economically viable. They started to rent those out. And that's fine. And I know your bill addresses that. They can use it to rent. But what was happening was that the state of Hawaii couldn't keep track of the lost revenues from those rentals, right? So there needs to be some methodology where revenue tax, Guam doesn't want to lose out on that taxable income. When the children decide to move on either into their own home or they move off island and the parents rent that out. There's got to be a venue or a methodology for Gov Guam to generate revenue from that rental. So that's I think to me is very important. The other thing that I want to talk, as Senator Dueñas stated, this is just one piece of solving the affordable housing project. Another program that Hawaii has is they put a certain percentage, I believe it's 5 or 10% of housing developments. If there is a housing development being built, 5 or 10% of those homes have to be for affordable housing. That's mandated by law. Okay, I'm not saying low-cost housing, I'm saying affordable housing. So the affordable housing is $350,000, and the homes are retailing for $700,000. They've got to put a certain percentage of those homes at $350,000. And that allows individuals to have access to affordable homes. We also need to revisit the possibility of GURA. GURA's here, and Chamorro Land Trust, of building affordable homes, mid 4 or 5 story homes, mid-rise, making condominium type, and working with a developer to see what they can do to build that. Kaiser is a great example of affordable housing that was a collaboration between the government of Guam and Kaiser. The government of Guam sold government property. I think I was talking to Joe Borja. We were both too young when that happened, but I think it was either $1 an acre or $1 a lot to the developer in exchange for building affordable homes. So I think these are things that we need to look at in order for us to fight this problem of affordable housing. I mean, I agree with you. Our people are leaving the island because they can't afford to live here anymore. The Hawaiians started leaving in 1980 because they couldn't afford to live in Hawaii anymore. So I think, there's a lot of things that need to be discussed, and I'm going to cut it short, but, you have a general idea of what I'm coming from. But I do support the bill, and you need to really move quickly on this. And heck, if the governor vetoes it, you've got enough to override it, so let's do it.
Thank you, Senator. Mr. Tejo?
Yeah, I'll go ahead and hold on to my testimony for now. If we could have an opportunity for the other, individuals to provide their testimony first.
Okay. Mr. Dueñas, would you like to go next?
Sure.
Thank you, sir.
I'm John Dueñas. I'm Vice Chair of the Government Affairs Committee of the Guam Association of Realtors. I'm also a professional civil engineer and the president of Dueñas Camacho and Associates. This testimony that I'm written testimonies in behalf of the Guam Association of Realtors. Senators, the Guam Association of Realtors is in full support of the intent and the provisions of Bill 5738 relative to allowing the construction of accessory dwelling units in residential zones. We specifically applaud the provisions that specify the ADUs be a permitted use in those named residential zones. The bill's intent is noble and impactful as it will provide two immediate positive and important benefits to our island community as follows. One, an affordable alternative to assisted living and other senior home businesses that are not yet available on a scale to meet the demands of Guam's aging population. And two, a unique and sound way to address Guam's severe housing shortage. We urge the 38th Guam Legislature to pass this bill as soon as possible. Personally, I do have a recommendation. Section 6114119, which is, I believe, on page 7 of the bill, provides that each lot shall be limited to one attached and one detached ADU. My recommendation is that only one ADU, attached or detached, be allowed in an R1 zone. The R1 zone, is embodied by the name single-family dwelling. You can have up to basically three families living in a single-family dwelling. My recommendation is that you allow one ADU in an R1 zone. The other zones, R2 and agricultural, I'm fine with having two ADUs, which, by the way, Senator Lamarina does allow for multiple ADUs, up to two. Also, I don't think the bill prevents going up. I mean, I just didn't see anything. So that's allowed. So I think the bill's fine that way. And that concludes my testimony. I support the bill. I have a recommendation, and that's it.
Thank you, Mr. Dueñas. I appreciate you. Mr. Borja?
Good morning, Mr. Chairman, and good morning, Senators.
Good morning, sir.
My testimony basically is a technical review of the bill. If it is public policy, as I think Senator Lamarina said, there's 11 sponsors, so I'll leave it at that. On the first page, or second page actually, where it says the purpose of this sub-article is to allow homeowners to construct residential accessory units, et cetera, on the same lot as a single-family home located on that. This is not my lane, but there might be a concern from the mortgager of the property if it is, being mortgaged to do something to the property that may affect its value. On that vein, if we are to do an application form for that, most of our application forms at land management require the owner's approval or a designated representative on that. So we would probably require the bank, if the bank's holding a mortgage on that property, to consent to the permit application, or rather the application. And again, that's not my lane, but we do require a land management on all our forms, the owner's consent. And in a case of a mortgage property, the bank is kind of like the owner for a while of that property. On the second page, I was speaking to Realtor John Dueñas out there, and why are buildings in square feet and land is in square meters? Usually, in this case, it's square feet to square feet, which is probably used to have a visual comparison of how much that ADU is going to take up of the lot on that. But normally, at least in my experience, buildings are in square feet and land is in square meters. And the conversion, of course, is smaller. As an example, most of the lots in Agana, the residential lots, they're mostly about 515 square meters. So that kind of hopefully gives you an idea of, the size of lot in a residential with like that. On line 8 there on page 3, on lots where existing septic tank sizes are not adequate for additional footprint, I think the formula is driven actually by occupants of the building rather than the footprint of the building. So taking into account Senator Lamorena's and John Dueñas' thing about being able to build up, your footprint there may be, 20 by 20, but your occupancy has increased 3 times on that footprint. So that may be a concern. The line 10 here is where I have a problem here where the confirmation of the relationship has to be done by land management. I feel this is like land management asking who's your daddy on that, and I don't want to put my staff in it, in that situation. But that's a tough one for us to handle, really, especially with the names like Cruz and Blas, common names, as well as the foreign names, which I have a tough time doing that myself. Line 21, number 5, 1 off-street parking space per accessory dwelling unit must be provided. And the question from the planning division here is, it's already in the law that 1 is required off-street, but is this an additional parking space requirement? On line 26, number 7, we have the word covenants in there. And I think that may be, if I'm not mistaken, the first appearance of the word covenant. But then later on the document there, like on page 4, line 5, where it says deed, are we talking about the same thing? Is the covenant the deed? And, the deed restrictions lapse. I'm not sure what that deed is, or is that the covenant? So that just to clarify that issue. And again, covenant is mentioned in number 13. What's that covenant? On the enforcement of these things, we probably should look at the B&B and the long-term rental. What are the rules for that? What's the, what is that? That's been in existence already for several years. Is it working? Is it not? So maybe take a look at that enforcement. Who's enforcing B&B? And maybe take a look at that and have them do it. So, okay, page 5. On line 3 here, number 10, where it says application of construction permit, I'm assuming that's a building permit. And again, in the mention of the word permit here, I'd like to ask that the authors be clear. What are we applying for? Construction permit, a building permit, business license permit, and like that, just to be clear in the application, because each of those different types of permits is actually administered by different agencies. Business license, I think revenue and tax, building permit, DPW. So just to be to clarify that issue. And then, of course, page 20, line 21 on page 5, number 13, DPW land management must be notified of the removal. And I'm assuming that's a demo permit, so, demolition removal requires a permit.
Mr. Borja, I'm sorry, just on the page 5, line 3 for the permit clarification, right? What recommendation do you give for the permitting, the permits there, or you just need clarification on what?
And again, that would probably come from land management, a building permit, an occupancy permit, what kind of permit on that? And it comes up to actually page 6, Mr. Chairman, on line 10, a permit application. What kind of permit application? Just to clarify that.
Thank you.
And, the rest of the pages here are basically we support, and their basic and ministerial help. Although I do want to mention that BMMR had requested for a fiscal note from the department whether this enactment of this law is going to cost the department any money, or do we require to get more desks and things like that. I did not submit a fiscal note to the BBMR to be submitted along with the bill before it goes on the floor for several reasons. Number one, the cost in this bill is basically advanced costs. It kind of like says you may charge fees to do that, but which comes first, the chicken or the egg? Do we charge fees first, or do we do that thing? So if the bill passes, we would probably be coming down here to ask for a supplemental appropriation specifically to the planning division for this. If you're going to do rules and regulations, you have to publicize it. Publication, I think, is $600 a shot, and before it comes down here for your final acceptance of those rules and regulations, which may take 90 to 120 days to do just by statute, notice factors and like that. So that might be an issue. Yeah, it's cost advance, and there has to be, I guess, rules and regulations on that. And I know my friend John here doesn't really like those tough rules and regulations, but we are committed to support the bill, and we'll see what we can work out about the mechanics on it. We are satisfied with the I guess regulations now. If you don't have adequate sewer on it, you don't get it. If GW or GPA, and I think GPA has their own rules and regulations about having 2 meters in R1, things like that. But that's GPA's lane, not land management. Thank you very much.
Thank you, Mr. Borja. I appreciate your testimony. Director Esteves, please.
Thank you, Mr. Chairman. And just to clarify, Deputy Director, thank you.
Thank you for that, Senator.
Thank you, Mr. Chairman, and Senator Dueñas for authoring the bill. Again, to the Vice Speaker on his initial authoring of the bill, GURA, and as stated before on the record, we do support the accessory dwelling unit building. I won't bore you with the need of housing. I think we did an entire summit on it. But I think it's important to mention, as many have discussed, and as you yourself, Senator, have discussed, about the population decline that we've been seeing. Of particular note, and this may move some people, depending on what their reasons are for vote up or down, that amongst that population decline over the last 10 years was a 15% decline in the Chamorro population on Guam. It's important to note. So I don't have written testimony. I'll provide my notes here on a markup of the bill from a technical perspective. Starting with page 2. Now, again, maybe this is more for land management to confirm, but based on the intent of the bill, it says R1, R2, and agricultural zones for ADUs, though I think this would already be a permitted use under R2. I may be wrong, and Joe Borja, Director Borja can correct me after the fact, so it may be unnecessary to put in there. Continuing down on page 2, lines 16 through 17, not so material to the bill, but maybe worth consideration that for ADUs with a shared entrance for attached ADUs, those would not be eligible for Section 8 vouchers based on the requirements of the inspection. So if that's an important consideration, just make a note of that. Moving down to section 61141, B1. We do have some concerns with the sizes of the ADUs that are being proposed. Again, less of a consideration if they're going vertical, perhaps, maybe more clarity on the language. But no issue with ADUs that are 400 square feet to 800 square feet. But when ADUs start getting to the size of 1,200 to 1,600 square feet, that's pretty much getting to the average size of most homes. It may be a better approach to extract that and consider, and we'd be happy to work with you towards the reduction reducing the minimum lot size for construction. It may be a better opportunity to address ADUs. Really, they would be houses of that size, and having them be allowed to be built on smaller lot sizes, I think would be a greater impact and overall benefit to housing development. Moving on to page 3. On lines 8 through 9, we do concur with the technical language that should be towards occupancy. So the typical standard is 2 people per bedroom. Also included, if you're going by the HUD standard, you would consider 2 people in a living room would provide you the overall max occupancy for safe, decent, sanitary housing, and that could be perhaps the standard for determining the size of the septic system. On line 12, and pretty much throughout item 4, we do have concerns. I specifically have concerns with the use of the word authorized representatives. So not so much in terms of applying for it, and I think that already exists, should there be, let's say, the power of attorney, but in defining property owner or owners, the language in there is very explicit to relatives by blood, marriage, adoption to the property owners. And I think in the previous bill, you also had, stepchildren, stepchildren as well. There's no argument with that. But then when you put the or and put designated authorized representative, you basically create a loophole that throws all of that out the window. Anybody can be an authorized representative with the sheet of paper. To consider them the property owner, I think would result in a situation where the property owners ultimately are not occupying the unit, and you basically have certain actors getting a 2-for-1 special on renting out units without actually living in the units or even living on the island. Something to consider. Line 14, active military deployment should be defined so that it's not construed to additionally mean somebody PCSing from Guam now able to rent out both the ADU and the primary house when they're temporarily away or they're not a resident. You could consider overall resident requirements, such as, are they a bona fide resident of Guam? Are they a taxpayer of Guam? As an example, do they file their taxes here on Guam, or do they file it with another state? But at the minimum, active military deployment should be defined clearly so that at least the regulatory agency knows what documents to ask for, and that we're meeting the intent of the bill. Particularly, it should not include the PCSing of military service members. Lines 21 to 22 should provide an alternative. It states 1 off-street parking spot per accessory dwelling unit must be provided, but shouldn't allow for an assessment should there be adequate street parking. So if you look at certain neighborhoods, Sinahanya, Asin, Zotnya, those were urban renewal projects. The streets are specifically designed to account for street parking. And so to allow for that assessment to take place, I think provides greater opportunity for residents to be able to use that and maximize the property that they do have. Moving on to page 4. Again, with lines 19 through 26, again, objection to the allowance of designated authorized representatives as a matter of rental. 25 through 26, actually 25 through 26 on page 4 and lines 1 to 2, it doesn't make a lot of sense to us. The expectation should be that anybody renting an ADU, whether it's a mom and pop operation or not, should have a valid business license as a means to track and regulate activities that are going on. Otherwise, with the exception of making sure it's not a short-term vacation, I don't believe the language is needed there for the month to month. If they are a business owner, they should be having a lease agreement for an extended period of time. If they opt to do a month to month, leave it to them to do that and assume that risk. But maybe the bill should make it clear, if it's not already clear and assumed, that anybody renting or transacting any business should have a valid business license for this. Page 6, starting on item 15, starting on line 10. This is less specific to GURA, but more of a general concern and experience in operations. 60 days may be an operational impediment. If you consider that, let's say there's a high demand for this, there's going to be a lot of permits coming in, and there's already delays in construction and of the sort. While I understand the need to streamline it, you may want to consider a phased approach. So at the initial launch, should the bill be passed and signed into law, maybe for the first year or 18 months, allow the relevant agencies up to 120 to 180 days, you guys work those numbers out, to allow before automatic approval happens. And then maybe after 18 months or a year, once that initial demand has gone down, then it automatically goes down to 60 or 90. That way you're able to account for that initial demand that comes up and you don't overburden the agency. Because what we don't want to happen is that because there's a lot of demand for it, a lot of permits come in and a lot are being approved with that 60-day turnaround, that it's really interfering with the ability for the agency to regulate and actually review. This is going to be new to many of them. Page 7, line 19, we're actually in favor to keep and allow for the one detached or one detached unit and having more. Between the requirements for wastewater, the requirements to have adequately sized septic systems, the setbacks, let the engineers be the engineers. Let them figure out how to engineer it in the property to those specs. If they can fit two, they can fit two. If they can fit one, they can fit one. At the end of the day, so long as the regulatory requirements are met in terms of environmental concerns and other concerns regarding safety and human habitation, let them do what they will. And provided if they're renting it, they have an adequate business license, or they have a valid business license and insurance, then there shouldn't, 2 is pretty reasonable still. Page 8, no issue with the setback. So if it's 4 feet from one property, you also have to consider that the total distance between the properties also includes the adjacent properties, right? So if you have a 4-foot setback here, 4-foot setback on the other property, you actually have an 8-foot distance between the two. The law already allows for the ability to, have signed agreements and concurrence with your neighbors and go through the process of putting up a fence if they so wish. So, with issues of privacy, that's already addressed. Now, if there are fire code issues, perhaps insert language in there, and I think we mentioned this in the Housing Summit, there are engineering ways to do that. So if my understanding, talking with planners and the engineers, the original setbacks were put into place was as a fire guard, right, to prevent fire from spreading. So long as the adjoining wall that is going to be within less distance of the other home, as long as that's a fire-rated wall, then that's how you address that. That's already covered in code. That's why you have commercial spaces with no setback between the units, because they build that for that specific reason. So maybe allowing that to be just be engineered by providing that language or option in there might be worth consideration, or could be an amendment in the future after some more fleshing out. But we wouldn't want it to hold back the bill in general, but just something to consider. So kind of to round off a couple of recommendations we have, additional enforcement language to ensure that ADUs are used as intended. And so while there are provisions in there to prevent it from being used as a short-term rental, such as a bed and breakfast, we want to be concerned too that they're not utilizing this, for example, as a home office or other commercial applications. So maybe adding language for use as intended to be put in the bill, which is for housing. It's not, I don't want to say adequately, it's not very clear in the bill. There are actually 3 types of ADUs. The bill doesn't actually define. It seems like attached ADUs and conversions are used interchangeably. If that's the case, that's fine. But we just wanted to make sure, and then we're seeking some clarity on that. And then the last item was perhaps prospectively considering language that at least clarifies legal responsibility as it relates to mail. Because a lot of official legal correspondence comes by way of mail. So for example, if, what we're imagining it, the potential for lawsuits. So if somebody's renting out the ADU, is the person living in the primary residence as the landlord, is he responsible for the mail? Will these ADUs have an alternate address? Has that been something that we've been able to work through with BSP to see how that would manage? Those are all things that can come prospectively, but at least inserting language that clarifies that, for example, even if it's simple as the landlord, if they're renting out the ADU, is not responsible for your mail, right? And so then that assumption goes out the window, and just making sure it's clear legally who is responsible for that. Other than that, those are just some technical points. I'll leave my notes for the committee, subject to your questions. Thank you.
Thank you, sir. Mr. Tejo?
Yeah, thank you. Let me go ahead and introduce myself. My name is Teo. I represent the Guam Chamber of Commerce. I'm also a professional engineer, so this is kind of the field that I've been familiar with. I have a written testimony here, and then after that, I provide my other feedback based on what was discussed. But I'd like to go ahead and read through my written testimony. Hafaday, Vice Speaker Atta, members of the Committee on Land, Environment, Housing and Agriculture, Parks and Infrastructure. On behalf of the Guam Chamber of Commerce, I write to express our support for the proposed legislation allowing homeowners to construct ADUs on their properties in residential zones R1, R2, and A. This initiative is vital for addressing the pressing housing challenges we face in Guam. We agree with the main objectives of the legislation as follows: increasing affordable housing options. If passed, this mandate would significantly increase availability of affordable housing within our local neighborhoods. ADUs would not require traditional new construction due to shared infrastructure and smaller footprint, which could potentially lead to lower costs for renters and increase property values. Support independent living for families. Allowing ADUs enables adult relatives such as elderly parents, grandparents, and adult children to live independently while remaining close to family, addressing the aging population's needs. As Guam's population ages, there is an increasing demand for affordable living arrangements for seniors, our Manamco. ADUs offer a cost-effective alternative to assisted living facilities. Regulating land use standards. The proposed regulations establish clear standards for the construction and use of ADUs, ensuring that they are safe and compliant with zoning laws. Encouraging community development. By allowing homeowners to build ADUs, we promote economic development within our communities. Homeowners can generate additional income through rental opportunities, which can stimulate our economy and enhance community stability. In conclusion, Bill number 26-38, permitting a ADU is a forward-thinking approach to tackling our dire housing needs on island and enhancing community living arrangements. It not only provides affordable housing solutions, but also supports family dynamics and addresses the needs of our aging population. We urge all members of the Guam legislature to support this important bill for the betterment of our community. Thank you for the opportunity to present our views and comments on this bill. We stand by to participate in any future discussions on this proposal. Besides that, I just wanted to kind of add on a few things to some of the things that were mentioned. I think Fernando Esteves had a very good point. There are certain ways that engineers can build a firewall so that it is within 4 feet of the neighbor. And these walls are supposed to be fire rated. That type of engineering system can be incorporated into the design so that some of the structure can get close to the property line. So there are definitely ways around it. In terms of rental, I know there's a little bit of a concern when it comes to rental. You know, the chamber, we feel that, you know, if landowners would like to take these properties and would like to, of course, in the beginning, you know, have it be used more for their family use, but in the long run, if it's going to be a rental unit, we feel that they should be encouraged to get business licenses. That's something that we feel that, you know, that needs to be done. There has to be some type of mechanism in order to do that, or some type of trigger. Lastly, I wanted to mention that there's already quite a bit of non-conforming illegal housing existing. And this is, I think, one way we might be able to bring some of the illegal non-conforming housing into the housing infrastructure. If these folks already have something built and they want to conform to the ADU requirement, then this is a time when they could make it conforming. And so that having that flexibility also when it comes to being close to their, I mean, I know for sure I've seen houses where they're built right up to the property line, but if they have a chance to make it conforming by moving their wall 4 feet back, I think that's one way they might be able to be more in conformance. So those are certain considerations. Yeah, thank you for the opportunity to speak.
Thank you, sir. I'd like to recognize my colleague. I apologize for not recognizing our leader, Senator Parkinson. Ms. Dueñas, did you want to also provide testimony? You noticed she came up, ma'am.
Yes, I'd like to provide oral testimony.
Thank you, ma'am.
I'm Liz Dueñas with Remax Diamond Realty, and I'm also part of the Guam Association of Realtors. I felt it was important to speak because I've been doing real estate close to 30 years, and many of my colleagues that are here will attest to the fact that in the past couple years, we're seeing more families, individual couples that are teaming up to rent a home. They're renting a house with 3 separate families or 4 separate families. And the reason being is they can't afford to rent in the regular market. So what they're doing is teaming up right now. It's really sad. And by the way, as realtors, we're here to service people. I know some of you may have said it's about money. I'm sorry. It's not about the money. It's about our people of Guam. And these people come to us because they can't afford. The Section 8 has raised their allowances to compete with the military market. What happens to our local people? They can't afford it. So we're seeing rentals. We try to price them so we can help people. And now they're teaming up. ADU is a step. Thank goodness there's 11 of you that are supporting it. ADU is a step to help these people find affordable places to live. If they can't buy, at least it'll help them start saving so that they can eventually afford. Interest rates are high. There's just so many issues right now in our current market. We're hoping those interest rates will drop to help. Many people who were able to buy had to put it on hold because of the interest rates. So again, I commend all of you for sponsoring and the rest of you who didn't sponsor to help move this bill forward, not just for us individually, but for the people of Guam. Thank you.
Thank you, ma'am. I appreciate your testimony. My colleagues will have 5 minutes to ask our participants questions, and I ask them again to please keep their questions relevant to the bill and to please keep within the 5-minute time frame. I would like to start off with the Vice Chair, Senator Dueñas.
Mr. Chair, if I could appeal that 5-minute rule, we have at least 6 panel members, and that's like 1 minute or less for each. And I think this is an important measure that really requires some discussion.
Thank you, Senator. The question will be limited to 5 minutes. It does not, we're not timing the participant for asking or responding to the question, so it's just the questions that we ask. So again, it will be 5 minutes. Your 5 minutes doesn't, or the 5 minutes doesn't count to your response to the senator's questions. Thank you. Vice Chair.
Titus Masi, Mr. Chairman, and I want to thank everyone for the very thoughtful testimony, and certainly the committee is eager, very eager, to mark up this bill and get it on the session floor as soon as possible. Mr. Chairman, I think by and large, the testimony has been very technical in nature in terms of what proposals have been put forward, so I'm very encouraged by that. Mr. Tejo, I wanted to address the fact that in the bill at this point in time to what you were saying about bringing into compliance. So on line 10, basically, I believe this is 6114 or maybe 3. At the time of the application for construction permit, the applicant shall first obtain written confirmation from responsible agencies, including Guam Water Works Authority, Guam Environmental Protection Agency, and the Department of Public Works, the wastewater treatment disposal. And then it goes on to say that the owner, the structure actually can also, under 12, the owner of a structure constructed without a building permit prior to effective date of this article, who wants to convert that structure to an accessory dwelling unit, shall obtain an after-the-fact building permit in addition to fulfilling the base requirements of the after-the-fact permit. And adjustments to the structure must conform to the accessory dwelling unit regulations enumerated in this section and any additional adopted policies. So in this bill already, there is the ability to go forward and get an after the fact and bring individuals into compliance who are currently not in compliance. So we believe that all of the permitting requirements and everything that have been included has been discussed, will suffice to be able to build this bill and make it even stronger as it becomes law. So Fernando, I think I was listening to you as mostly the objectionable over the 4 and 800 or 900. So I wanted to just ask you this question as Senator Lamarena put forward, and I think would an amendment, and maybe the panel, would an amendment to allow for that square footage on vertical construction, would that be a proper amendment?
I think it would. It wouldn't hurt. I think our primary concern was that it be used as a poor man's subdivision, right, and really be a far removal from the intent of the bill. I don't have an objection on going vertical if, let's say, the footprint was of a single story, 400 to 800 would be not unreasonable, right? 400 could be 800, 800 could kind of be the max. But from a policy perspective, anything more than 800 square feet of living area really should be addressed more in terms of either the subdivision laws and minimum lot size and construction and minimum lot sizes. So I would say 800 really being the max, whether you're going vertical or your single story. And just as a reference, we've built 3-bedroom, 2-bath houses that were 900 square feet. These were GURA affordable homes constructed back when they were affordable to build, back in, I want to say, 2004, 2003. So, really going into that gray area.
Thank you, Mr. Chairman. I look forward to the questions from the other panel members.
Thank you, Vice Chair. Senator Gumataotao, do you have any questions?
Yes, thank you, Mr. Chair, and thanks for everyone for being here, and thank you for our former senators. It seems that in my first, run as in these public hearings to have senators here, I think we're in great company in terms of creating good public policy for this community. Let me just say publicly that 13 states have enacted legislation that loosens ADU construction restrictions, and this measure is a common sense solution that addresses one of the most pressing issues facing the hardworking Guam residents, and I really do believe that Bill 57 is taking us in that direction. It was mentioned earlier by Mr. Borja, and thank you, Joe, for being here with us, about the fiscal note waiver. And there, it is administrative in nature. BBMR said that it did not pose any fiscal impact, but you're absolutely correct. We're going to have to go in the budget and working with the committees to make sure that we can address the enforcement issues that the statute, when it's enacted, will place. So thank you again for pointing that out to us. I did want to bring up one thing, if I could. Thankfully, thank you, Senator, for being with us as well. I wanted just to say this. According to the 2020 census, 15.3%, or 5,325 households of the estimated 34,804 family households across our island were multi-generational. For reference, of the 145,543 people in households whose poverty status is determined, about 20% had incomes below the poverty level. So I wanted to ask you, what information can you share with us today, or at this point, regarding the portion of the estimated 34,804 multi-generational family households that include senior citizens, and is there sufficient housing inventory that would be available for our Manumco through the Guam Housing and Urban Renewal Authority, especially if this law is enacted? Will it be able to support?
Thank you for that, Senator. Maybe we can clarify. Going back to the main part of the question that I was trying to make sure I understand. Is there enough housing for the 34,000 based on the census that fall below the poverty line with particular interest in the Manumco? Was that the question, Senator?
Yeah, it is.
Okay. No. The answer is no. I mean, there's not enough housing for the island, period. In particular, when it comes to single bedroom or studio type units that generally will house young professionals that maybe just got married or they're together, maybe one child or a baby, that's common. Single mothers or single parents, especially those that are escaping domestic violence situations, and Manumco who are looking to downsize, and because their kids are out of the house, likely moved off island, and it's too much for them to take care of. That's who I think would benefit the greatest from the ADU in its traditional sense, right? A unit between 400 to 800 square feet in size, and that's where a lot of the shortage is.
Thank you. And I know, Mr. Chair, I think we're going to have to probably get to it in the markup, and I look excited to hear about it. But again, there is a 3-year-old public law that authorizes a special qualifying certificate for developers who engage in constructing or substantially renovating existing facilities in order to accommodate the housing needs of our Manumco. And I'm hoping that at some point that we could get to it in this. But I just want to say I absolutely support this legislation, Mr. Chair, to promote economic self-sufficiency in our community and address the shortages in housing supply. We can go on and on about the housing summit that you had recently, but I think these housing affordability problems in our U.S. territory need to be addressed and need to be addressed right now. Thank you, Mr. Chairman.
Thank you, Senator Gumataotao. Senator Terlahi, any questions for the panel?
Situs Masi, thank you all for your testimony this morning. I'm very hopeful that, first of all, I appreciate pointing out that there are improvements in this version of the bill versus the previous bills. And one of them was that our committee took the Hawaii legislation and substituted the bill pretty much with many of the regulations and we did that because of the testimony by land management on the first iteration of the bill, the testimony of the Realtors on the second version of the bill that really was concerned that without any of these regulations or specificity that we were just, this would just be another way to make money by creating duplexes in R1 zones. And like Gura was saying this morning, the concern about the poor man's subdivision. This is what we've seen in some other places like Puerto Rico. That's what it's turned into. Only those poor people are going to be, if they're allowed to use it for rental, then that's what it ends up to be. As opposed to, the bill is very clear in its intent in the beginning, in the intent part, binding or not is a question, right, that says it's for adult relatives to live near you. And I think nobody objects to that. We all want this, and we want that as soon as possible. Then it prohibits its use for bed and breakfast, short-term dwelling, but then it says it may be rented. And I don't think it's clear, like you said, somebody said, in the beginning you give it to your family and then you rent it out. So it's really just going to turn into a R2 in an R1 zone, or a poor man's dwelling. The ones who can't afford anything else are going to go this place with no yard of their own, sometimes even access, I guess. Would GURA cover this type of living for a non-relative?
Absolutely, provided it meets the minimum requirements for physical space. And I mentioned that in the beginning of my testimony. If, for example, if it's an attached ADU and it's a shared entrance, that would not be eligible under the physical requirements for Section 8 rental.
All right, and I think that authorized representative language came from the Hawaii statute, but the bill is missing one provision that says the home or the ADU shall be occupied by the owner, right? And unless that owner has an issue, like a health issue, has to go someplace, then they can designate a representative. So I'm hoping that will be a technical amendment that can be made to the bill. I appreciate your testimony, Mr. Dueñas, regarding the R1s in particular, that allowing only one. And I know, I agree with you, it looks like this can allow going up, and one in an R1 zone is reasonable. My concern is that, yeah, we are allowing those who, without building permits, to use this statute. I think they should be able to, if they're sincere, to convert their properties right now, even without this, or under the guise of an ADU, that they should convert their properties, particularly the setbacks. So this bill reduces setbacks for R1 zones on the sides from 8 to 4 feet. It allows that. I don't agree with that. I don't think that's what anyone who's in an existing R1 zone relied on when they built their house. And on the rear, the bill reduces setbacks from 10 feet to 4 feet. Again, I just think if we're going to reduce setbacks for all houses in Guam, then we should address that. But to reduce it only for ADUs, I don't think that addresses why we have setbacks in the first place. One of them was privacy, according to one of the testimony, but there's other things that are recognized. That's access for fire departments, it's emergencies, the natural light for your neighbors, the ventilation, the sound, aesthetics, and privacy. Those are the recognized purposes of the setbacks. And then, of course, the deed restrictions. I agree, land management. Are you going to be able to prepare rules and regulations based on the way the bill is written right now?
We would prefer to answer that when the bill is passed, because...
Well, as it's written now is the question.
Yes, I would think so, other than the requirement that it be the owner to make the application. But I don't see anything in here that would prevent us from doing rules and regulations.
Okay, and then DLM will be doing a ministerial review, not a discretionary review. What would that mean? According to the bill, it says you're going to do a ministerial versus a discretionary.
Follow the rules.
Pardon? Yeah.
Follow the law, follow the rules, no
All right.
discretion.
And how is that different from what the GLUC does right now?
Which one? Following the law and following
Yeah.
the rules? The GAUC follows it. I mean,
All right, so that means DLM is going to do the reviews. What if there is a concern from an agency? So you only have one choice, to deny or approve, or if you don't act within 60 days, according to the bill, it's a default
an
approval.
automatic approval.
Pardon?
It's an automatic approval.
Right.
Yeah.
Yeah, so how will the other agencies weigh in like they would on a normal conditional use application? They won't, right?
It depends on the permit because, you know, for land management, most of our permit clearance really is the land use, the zoning part. The other agencies, they're the technical review people.
Right,
Yeah.
but this bill doesn't require that. It requires land management's ministerial review of an application. So my question to you is, it seems, are you going to review it under the DLM like you do your DLM approvals? Or are you going to review it for all agencies?
The bill says land management.
Right.
Yeah.
So land management will be making the determination whether it complied with EPA, GWA, and all of those agencies.
That's in the building permit
in its
process.
application. Pardon?
That's in the building permit process.
Right, but you
Yeah.
pointed out that the bill talks about occupancy permit in one point.
Oh, it
No,
doesn't,
maybe
talk, it
actually
doesn't talk about occupancy.
It doesn't
permit
mention
then, yeah.
occupancy. It says construction permit, and I think it said building permit, and then it just says permitting by
It doesn't say building
DLM.
permit either. And that's
Yeah.
my thing is, let's clarify what permit are we talking about?
Yes. Don't those, and if, but does the permit have to be required before DLM approves the ADU? Because it sounds like it's creating a separate process for DLM to approve by default.
Well, we
these
can't
ADUs.
approve it if we don't have the rules and regulations, Speaker,
That's
Senator.
right.
Yeah. So we need to do the rules and regulations first.
And how are you going to write the rules when the bill conflicts with what type of permits are required?
Mr. Borja, can you speak directly into the mic? I could barely hear you. Thank you.
What was the question, Senator?
I'm going to move on because, yeah. Anyways, does
Senator,
this
you're-
bill restrict it to adult relatives only? The ADU occupants?
Yes, and that was my concern. I don't want to be the one asking, you know, your relationship on it. You know, there's got to be another agency to do that. I mean, I could accept a sworn statement.
Yeah, in other places they use an affidavit. I see you should be able to do that. But is it your interpretation of the bill that it allows adult relatives only, or as GURA points out, it could be rented out to anybody, non-relatives?
There's varying parts of the bill that changes. You know, there's a qualification as a rent-to unit later on in the bill. You know, that's public policy, Senator. I don't have any...
As written, what is
Thank you.
you're the one enforcing
Senator?
the bill, so I'd like to know
Senator,
your interpretation.
Your time is already up. Thank you.
Yes, if he could
Thank you,
please
Mr. Borja.
answer the question, though.
Thank you, Mr. Borja.
Please.
Senator Lujan.
Mr. Chair,
you're
if he
next.
could answer that, that's critical, that's the crucial part of the bill, is whether it's going to follow its intent, whether DLM is going to be able to follow its intent, or it's going to depart to some unintended consequence.
Thank you, Senator.
If he
Senator
could please
Lujan.
answer, Mr. Chair.
Thank you, Mr. Chair. Morning, panel. Thank you very much for being here this morning. As was mentioned before, this is the third round of this bill, and I was actually part of the second round. Now this is being the third, but thank you again to the author for asking me as well again to be a co-author in this bill. It's a common sense bill, and all the testimonies have been put forth with this. I mean, yeah, we all wish we had the income and the opportunity to be able to live on Rodeo Drive, right? But we don't. We don't. And so that being said, again, it's common sense legislation. There was a question asked earlier about whether or not we had enough homes for the Manumcos. It's high time that the legislature look at these regressive policies that we've had over the years to reflect our current status here in Guam. As mentioned earlier, quite a few people, and since the round 2, now being round 3, thousands of people have left since round 2
of this version of the bill. Back in, I think it was 27th or 28th Guam legislature, Gumataotao had the opportunity to go vertical. It would have housed about, I think, maybe 200 plus manamkos at the time. There was a bill that said they could not go vertical. Now, I mean, a manamko to go down to Gumataotao, someone has to die to be able to go in there. They want to go horizontal. Are you kidding me? I'm working on a bill to repeal that law, to give you guys the opportunity. If the bill would have passed at that time, GURA would have been housing 200 plus Banamkos down there. There would have been temporarily, the residents that were living down there would have been temporarily housed at Ironwood, and they would have been given the first rights of refusal as to where they wanted to stay in the I think if it's 5 stories, I think, right? 3 or 5 stories. Yeah, 5 stories at the time. It has to be revisited again. Again, you just mentioned, and the summit, again, proved the need of affordable homes. These Manamkos that are down there are folks that cannot afford any dwellings. So again, it's about time that we look at policy that is regressive and unfriendly to the environment that we are currently in. And I'm glad that we have 11 co-sponsors with this. There are some modifications in markup that will happen. But it's about time that the legislature works on common sense policy that is good, productive for the people of Guam. I mean, we're looking at, whether or not having to worry about whether to get licenses and eventually it's going to be a rental unit. Well, how about the people who have left? They may have sold their homes, or they may have rented them out. And if they have left, and if they rented them out, we need to look at ourselves in the mirror and say, what did we contribute to them leaving? What did this body contribute to them leaving? Each one of us has to look in the mirror and ask ourselves that question. We have an opportunity in bills such as this, 57-38 COR, to start making policy, crafting policy that's good for our people, that makes sense for our people, to give dignity to our people. That being said, that's it. This is my second round of this, this bill, so thank you very much, Mr. Chairman. Thank you.
Thank you, Senator Lujan. Senator Calvo?
Thank you, Mr. Chair. Have a day, buenas, everyone. Thank you to the panel, to all the individuals that provided testimonies. And I'd like to thank the author of the bill for inviting me to co-sponsor. I'd like to focus on the benefits of the bill to begin with. We all know that this bill expands the opportunities for housing availability. It creates affordable housing options, not just affordable housing options, but truly it creates, it makes housing attainable for individuals. It also generates income for homeowners. And I like the fact that this encourages multi-generational living, where families can house elderly relatives or adult children together. It also promotes efficient use of land space for families. And obviously, because of the economic impact that it can provide to our community, it boosts local economy. I do understand from the testimonies that we have concerns and considerations that we need to be mindful about, such as community impact, neighborhood density, infrastructure and public services impact, and probably tax implications. But to be honest, I know that we brought up concerns on the table, but I still do very much support this bill because it makes sense for our community, especially we have a depleted inventory in housing. Now, the pros heavily weights over the cons. So on that note, I just have a few questions that I'd like to address. First, the Department of Land Management. Are there concerns about overcrowding or land use conflicts if too many ADUs are built in certain places? And if so, what processes would be put into place to approve or deny ADU permit applications fairly and efficiently?
That would come, of course, Senator, that would come, of course, during the rules and regulations period. And again, you know, the laws, rules have to be applied ministerially. It's no discretion.
Okay. Thank you, sir. For GURA, we already know that this there's affordable housing crisis, right? And this ADU bill will help address that for our community. And could ADU be used for government housing assistance program, such as Section 8?
Provided requirements are met, absolutely. It's already done throughout the country.
Are there federal or local funding sources, like HUD grants, tax incentives, that could support ADU construction for low-income residents?
It's actually something we're looking into right now with the development block grant that we received, the disaster recovery block grant that we received.
Thank you, sir. Last for this one's for Department of Revenue Tax, but I'll just save that. Anyways, thank you so much for all your testimonies and for your answers, and thank you again to my colleagues.
Thank you, Senator Calvo. Senator Taidui, ma'am.
For the sake of time, hello, everybody. Let's get to the questions. Mr. Borja, do you think on the AAA process, where in the rules in this bill does it say that you have to create rules and regulations? What part?
Senator Taitui, that would come under page 3, line 10, number 4.
Is that the property owner or owners of persons who are relative? That's what I'm seeing on page 3, line 10, number 4?
Mm-hmm.
Okay, it says here that for the purpose of section designated authorized representative means a person designated property owner, department of land manager responsible for managing property. It doesn't say they have to go through a AAA process?
Or anytime you create rules and regulations, the government, you have to create.
I'm sorry, can you talk in the echo in here?
Anytime that you create rules and regulations on behalf of the government, you have to go to the, it's actually called the administrative adjudication law.
There's nothing in this section that says that. Where? Can you read the direct section for me, please?
You know, Senator, it's, to me, it's just common sense. It begs for regulation. You know, look at the entire section.
Why don't you read it for us, for the public to hear it as well?
Okay. The property owner or owners or persons who are related by blood, marriage, or adoption to the property owners or designated authorized representative shall occupy the building permit. What type of documents do these property owners or persons who are related by blood marriage have to submit? What is acceptable to the department? That would be in the rules and regulations. The law says...
It doesn't say rules and regulations. That Department of Land Management shall create rules and regulations or even go through a AAA process. That's what I'm trying to get at. If that's needed for this legislation to incorporate, then I think we should incorporate it. But it doesn't say that. I think it's important, too, that we look at the, provide the public opinion as well as the municipality of the area to also chime into this.
Senator, if it's your public policy that rules and regulations are not in there and it's not in the bill, when the bill passes, then it won't be.
Okay, so it's not in there, is basically what it is. Do you think that the municipality, or at least the area in which this bill is being processed through, to allow the public to get involved?
I can't really speak for the municipalities on that, but the rules and regulations would be page 6, line 23, which basically says the permitting agency may charge a fee to reimburse it for costs incurred to implement, including the costs of adopting or amending any regulations that provides for the creation of an ADU. So that's basically plain language that you have to have a regulation to do that. And that's what I mentioned in the beginning about the fiscal note, is that I did not want to give an amount because I don't know what, in the final form of the bill, what would be required. If we're required to do rules and regulations, which I think it is, page 6, line 23, all the way down to line 27, including the cost of adopting or amending any regulation, rules and regulations.
Yeah, but it doesn't force you to do it. So that's my point. And I think that we need to just clarify
Well, if it doesn't force me to do it, and I have the discretion from the final bill that's signed into law, then
you
more
have
power
discretion
to the director.
Okay, so you can just create rules and regulations without a bill telling you to do so, regardless if the bill passes. Is that what you're saying?
No.
Okay, but that's exactly what you said. So moving on, even when you're zoning property, don't you have like a sign that's put up saying that this property is going to be zoned, and it gives warning to the surrounding area, is that correct?
Yes, that's part of the application process.
Okay, and
for those rezoning application variances and things like that.
Okay. Do you think that should happen for the same thing if someone's putting up one of these, the ADUs in their property, that they should notify the surrounding area that one is going to be put up?
Well, my thought, Senator, is not really important. It's the public policy that you guys decide.
Okay. Do you think there's going to be potential of increased noises and parking issues and traffic that will cause in an area?
I can't predict that,
Okay.
Senator.
Ms. Dueñas, will the property value go down in an area that's considered overcrowded or have issues with heavy traffic? What are we looking at property value now for people if the
For
area
sure,
gets
right now,
overcrowded?
prices have gone up, and the local our locals who are in the 400 price range can't find anything.
No, I'm
So
asking
in
you.
terms of value, your question is, in terms of value, how would that affect it? When appraisers go and look at properties, they value size, location. I don't know whether the appraisers will take into account a neighborhood. Usually they're more attractive neighborhoods that, of course, may have, as they put it, location, location, location. But every individual is different. You have different buyers who have different tastes and styles. So, again, values is based on size of the property, the improvement on the property, et cetera. So in terms of the neighborhood, it's objective. It's up to the individual to see how that is. But an appraiser looks at concrete stuff. They look at size, improvements. They look at size of the lot, size of the house.
Do they also look at overcrowdedness, heavy traffic, congestion in that area as well?
I doubt that they would look at all of that,
but normally
they look
they
at
do.
the,
Okay, thank you,
look
Mrs.
at the
Borja.
subject property.
I mean, Mrs.
itself.
Dueñas. Yeah, thank you so much for that. Is there enough, Mr. Borja, is there enough enforcement or manpower to monitor the concerns such as infrastructure, environmental? I mean, this not just includes the cost for land management to oversee this, enforce this, but also rev and tax as well as EPA. Do you see a cost with that in enforcement?
Could you repeat the question, Senator?
Okay, well, is that a way to lose my time here?
Oh, no.
Okay, I'm okay to repeat it?
That was
Okay.
a long question, Senator.
Do you see, no, I just want to make
And
sure
it was
my
for
time is
another
not being.
agency, I think.
I'm sorry, say again?
I think it's a long question, and I think it's for another agency.
Well, it's actually for you too, but,
Okay.
the cost that it's going to incur, like I said earlier, is this going to cost public health, Department of Land Management, as well as EPA, as well as Rev and Tax and DPW to enforce this, or the manpower needed to monitor, an inspection and to make sure that they're complying with zoning laws and permits and infrastructure and environmental. Do you think there's going to be an additional cost for not just yourself, but other agencies?
We just kind of have to look at the basics. It's a building. Enforcement of, the building code that's no different, than any other thing like that. Insofar as cost for land management to implement the program, that's what I mentioned earlier. I don't know the cost of it. It depends. Are you going to require yearly inspections? Are you going to require any inspection at all?
Okay, thank you, Mr. Borja.
Thank you very much,
Mr. Seves, when you have an opportunity, can you look at Public Law 36111, which creates QCs for independent living for elderly and opportunities related to this bill? I appreciate all the comments that you made, Mr. Seves. A lot of the stuff makes sense, but one of the biggest concerns I have is this back and forth, whether it's for relatives or just anybody off the street to rent out, and that's a concern that's not clear in the legislation. So, you say you can, then Mr. Borja said it has to be proven that you're related. So that's something, you want to make any comment to that? This is my last question, Mr. Chair.
Yeah, absolutely. And thank you, Senator, for the opportunity to clarify. Let's start with the most important thing. And I think maybe it's worth going back to the second bill that was drafted, because that was much more clear. The most important thing is that the ADU or the primary residence is owner occupied. That is the most important thing. Let me be clear on that. That one of the 2 units or one of the 3 units, should it be up to 2 additional 2 ADUs, that it be owner occupied, 1,000%. Otherwise, again, it turns into an investor's paradise in a poor man's subdivision. And that's where we're absolutely against that. Now, in the previous bill, owner was defined fairly broadly in a way that we supported, meant the legal owner the children, grandparents, parents, other blood relatives, stepchild, and that's fine. That really makes sense for Guam. So long as owner is defined in that respect, we're fine with it. What we don't want owner to additionally define is any authorized representative, which is just a loophole to do exactly what we don't want it to do, which is instead of somebody buying a house that they want to make a rental, they're going to buy a house, add 2 ADUs, not live in the house, and rent it out to 3 different people. High likelihood they don't even live on Guam when they do it. And so that's absolutely not what we're promoting here. So owner occupancy is the most critical factor, provided with few exceptions to emergencies and things outside of their control, and that owner occupied be defined how the body wants to define it, but definitely not an open-ended, authorized representative model. Yeah. Hope that answers the question, Senator.
Well, that's a part about the owner, but I asked about, those who are also renting. Is it a relative or, that's what my question was, a relative versus someone. And, also this has to do with workforce, the workforce group coming in here, renting, is that?
No, exactly. I mean, so long as one of the units is owner occupied, by the definition, there's no issue with renting the unit out, right? If it's the owner of the house, let's say, an elderly couple, right, renting to their nephew, and they can only pay $200 a month or $300, so be it. Let that business transaction happen in the front for everyone to see, right? And let that be allowed. And all of the legal protections that come with being able to rent it out and have that business, right, that come to the person who owns the property, who is transacting business in the light of day. And so we don't have any issue with the rental, provided that the property, whether it's one of the ADUs or the primary residence, is owner occupied.
Yeah, but the bill says like 2 different, you can and you can't, relative or no relative.
Yeah, and that's why we provided testimony, Senator, to provide technical clarification, and we hope that in markup that those adjustments be incorporated into the bill.
Well, I greatly appreciate the the chairman as well as vice speaker who introduced this bill to bring to light the need for extra housing, and appreciate that the movement on it. He put a lot of work into it, Mr. Vice Chair, and I greatly appreciate it. And I too believe that it's important that we address the concerns, but we also have to be conscious about the public, what this will do to property value, what this will do to the privacy issue that Senator Lamarena brought up, and most especially the congestion that it brings with noise, as well as traffic and parking. There's a lot of concerns, and I think that the public should be be a part, actually, of the making of this legislation. So I hope that we can have a AAA process that will bring the public involvement so that they can issue out their concerns, especially when it comes to property value. Thank you, Mr. Chair.
Thank you, Senator Tidley. Senator Barnett.
Good morning, Sidos Masi, Mr. Chair. I think we just save ourselves a lot of trouble if we just heard from the author or the sponsors whether or not the intent of the bill is to allow the owners to occupy any one of the properties, or is it to allow the opportunity for a property owner to not reside on the property and rent out the house and any attached or detached ADUs. So it would just save us a lot of trouble instead of all this humming trying to read everyone's mind. Thank you for your testimony. There's a lot of technical stuff, a lot of markup work. I agree this bill seems to have a lot more safeguards and guardrails than the previous versions. But I kind of disagree with the sentiment that because the legislature failed to move on this ADU legislation, that it's a direct cause of our people leaving island. Our people not only can't afford to pay rent here, and I know because I'm probably the only renter sitting on this senatorial panel. Not only can our people afford to, they can't afford to pay rent, they can't afford to own a home, they can't afford eggs, they can't afford health insurance, they can't afford just the cost of living, and that's why they're leaving island. I haven't heard anybody, Chamorro or not, say, I'm going to leave island because God donuts that damn legislature, they couldn't get me into one of those hobbit houses. And, you know, I understand that this is part of a solution, but for me, when we talk about dignity, our people should have the dignity to be able to own a home and not necessarily rent and try and squeeze in a young family on a property, whether it's a little ADU or one of the bigger house sizes ones that's proposed in the bill. And so I guess I would just wait for the author and the sponsors to kind of clarify what the intent of the bill is, because it is a little contradictory. And I think that's it. Thank you. Mr. Chair.
Thank you, Senator Barnett. Senator Matanane?
Thank you to the panel for appearing today and testifying in support of the legislation. And I appreciate the concerns from my colleagues on this bill, and I look forward to working together to make it a better bill and including the suggestions for amendments. But I agree with former Senator Tony Lamarena that there is this sense of urgency. And again, I look forward to working with my colleagues to pass this bill in the 38th Guam legislature. Thank you.
Thank you, Senator Matanane. Senator Parkinson, sir, please.
Thank you, Mr. Chair. I stand in full support of this bill, and I just want to read a message I got from a father who was looking to take care of his disabled daughter, because ultimately it was his testimony that put me in support of this bill. Hafaday, Senator Parkinson. My apologies for approaching you emotionally today. I'm sure you were shocked and didn't understand a word I said. I was just so happy and thankful for your support and help with my daughter with special needs. She has seizure disorders that require constant monitoring and dependent for the rest of her life. She constantly gets admitted to control her seizures. Should this ADU bill pass, I could extend or build and use it as an incentive to cut costs for her caregiving. Thank you, John Q. Santos. And for me, ultimately, this is what convinced me that we needed to do something to make housing more affordable and more available to people here on Guam. And I appreciate the dialogue that went into this, because I believe in the Socratic dialogue. I believe that ideas that get challenged get stronger, and I appreciate that we've had 3 rounds of discussion on this bill to get this bill as strong as humanly possible. I agree with the former senator that it is important that we are very clear on what this bill is trying to do, and that is trying to make it so that families can help take care of their families, not as a backdoor for suburban slums. And so I really do appreciate the commentary and the suggestions on that. And as I look at this bill, I see that there are 11 co-sponsors on this bill. So from my perspective, this bill is going to pass. So it is much more incumbent on everybody who has a stake in this conversation to truly let your voice heard in this public hearing or when they accept written testimony afterwards. Because if this bill is going to pass, let's make sure we get all the input we need to make sure it's the best possible version of the bill that we can get. Now, no legislation is ever going to be perfect. That being said, we will try our best. We will try our best. I've heard the conversations about, you know, what's this going to do to our environment, to congestion, to parking, all those things. But as a community, we got to make sure we find ways to keep people on our island, to keep things more affordable. And I know how expensive things are on this island. My colleague was saying he might be the only renter on this panel. Hey, I might be the only person on this panel still living in his mom's house. That's how hard it is. Even I, as a senator, cannot do it alone. I have to rely on my family. I have to live in a multi-generational household with 3 generations of us in there just to make ends meet. And if those are the struggles I am going through as an elected official, how much more just the average person out there is suffering? So I greatly support this, and I am glad that we have had 3 rounds of discussion on it. And thank you so much for the author for letting me be one of the co-sponsors. I believe in the Socratic method, so please give your input, and let's make this bill as strong as we possibly can. With that, I yield the rest of my time. Thank you, Mr. Chair.
Thank you, Senator Parkinson. Mr. Tay?
Would I be able to speak? I wanted to add in a few more items if possible. I think it's important to note here that I think there is a difference of the way people are thinking here, right? On one side, you have certain folks that believe that, hey, these ADUs should only be for family members, right? And then ADUs should not be rented. But I think it's important to note that right now, if you look at the MLS, you're talking about rental units that are going at like 1,200, and then suddenly it goes to 2,400. You have nothing in between. You have nothing in between. And that's why we have this housing crisis. If ADUs can be a public service by, let's say, having affordable rental that are below 1,200, why is it a problem? Why is it that I, as a homeowner, initially with the intent of building a place for my children, let's say, and they move on, and later on I decide I want to rent it out, serving the community, serving the new couples, serving people that are newlywed that want to find an affordable home. Why is that an issue? I can't seem to understand that. If I decide to move on at a later point and decide if I want to rent this place out at an affordable range to people, to younger folks that need a place to start out, I don't see a problem with that. I think as investors or even as homeowners, we are serving a purpose in the community. And that purpose is bringing affordable housing to Guam, right? And so to label investors as just money hungry, folks that just want to collect rent, I think that's the wrong way to look at it. I think investors do serve a purpose, and that purpose is bringing that affordable rental market to the younger folks. And I think that's all I wanted to add. Thank you.
Thank you, sir. Senator?
I agree. I mean, I think the intent of the ADU is for family. And the things change. Both my sons are moved off island. And if I had built an ADU and they move off island, what am I going to do with it? I think a good compromise is probably to put in the legislation that it be relative or family occupied for the first 5 years. After 5 years, the complexion changes, then you can rent it out. But I think the intent of the bill is to provide affordable housing for our families. And, put that they do it in Hawaii remember I had mentioned where a development has to sell a certain percentage of houses for affordable housing. The main concern of the realtors there, where you've got these investors who are buying these, scooping these up, and then reselling it at a higher value. So what they did was they amended the law that required that the owner live in that property for at least 5 years. So I think maybe a good compromise is the family or the relatives have to live in the property for 5 years.
Thank you, Senator. Ms. Campos, you're raising your hand back there. No, ma'am. You know what? If you have a testimony, I see your name here, but I didn't see whether you had a written or oral testimony.
I wanted.
Turn on your mic and identify yourself.
I'll make it quick because I know everybody needs to get out of here. But, we're offering, I've heard some testimony about, green space and having privacy walls. and so many other things. And I just think if you haven't had a meal, having dessert isn't going to be of benefit to anyone. And that's kind of what I see this bill addresses. It provides the meal, because without affordable housing, we're worried about the wrong thing at this point. Maybe we'll get there someday, but right now, let's make sure our citizens can have a meal, a home to live in that's affordable. And the other thing that we're not taking into account, how many people in this room, how many people up there can actually say, I'm going to build an ADU and I'm going to use cash to do it? Because if you don't have the cash to do it, you have to find a way to pay for it after it's built. And that's where the rental comes in. I may want to do an ADU on my property, but if I don't have the money to build it, it isn't going to get done. And I completely agree with some of the panel members. We should have the ability to rent it out. And yes, it may not be my son or daughter living in that home, but it'll be someone else's who could surely use affordable unit. And I just wanted to put that out there, because although the concerns about having green space, having privacy, the density, yes, those are great concerns, but not when you're still looking for a decent place to live. I just wanted to put that on the table for you guys to consider. Thank you.
Thank you, Ms. Campos. I'll go ahead and give the author a closing statement.
Mr. Chairman, and I thank everyone for showing up today to help make this bill better. A few observations, Mr. Chairman. First of all, Director Borja and others, we will ensure to quickly make the technical amendments to this bill to have it move forward. I want to make it abundantly clear, and I know some of us listen to others on media, some of us don't, but I want to say that I've been on the record since I first endeavored to take over the helm from Senator Ada to introduce this bill, that I always intended for it to have the capability of one of the units to be rented, whether it be the primary or the ADU, as an owner-occupied, meaning the owner stays in one or the other of the units. As was just testified to, and I'm sorry, but I take exception, I believe a lot of people have left Island for this primary reason, because it is the most costly outside of all the other cost factors that are being discussed. The issue is, even now, because of construction costs, these are not going to be cheap to construct. They are going to be, if done right, and of course having to be permitted, they will be at the same square footage rate that most construction is right now, between $225 and $275 a square foot. There is going to be, more than likely, almost every one of these that are done, with the exception of those that are so soluble with cash, there will be a mortgage on this, probably a second mortgage to an existing residence. That ability to recoup that investment, if, say, for example, the family that allowed and the dignity of their young people who got married or starting a family to stay there, and that family moved on for some reason, and now they still have this expense because they did it, should be able to rent it. And besides, let's address this straight up front here. I'm glad that some of my staff have sent this to me. When you rent something, you must get a business license. That takes care of all the regulatory back and forth that we've been talking here. If you're talking about something outside of the bounds, well, that's a whole different ballgame. That's the law. That's enforcement. And I'll tell you another thing. I've heard this time and time again on other pieces of legislation. If we are going to, as a government and as elected representatives, tell the people of Guam, because we can't regulate, we can't enforce, you can't have a quality of life, then fire us all. It's our job to regulate. It's our job to enforce. If we need to build that capacity, then doggone it, that's where that starts, right here. But we shouldn't put the burden on people who are just trying to duplicate something that has performed well in so many other jurisdictions to provide opportunities, because we, the government, haven't caught up with the times. or haven't gotten on our regulatory agencies to do their job, to help our people. In closing, I get that there has been this back and forth of how much work has gone into this bill and what's been done and what's not been done. But I'm going to say, it's very rich to have criticized those who introduced solutions, but never have introduced it yourself. I take full exception to that. If you are so capable of constructing and destructing those who introduce legislation, but you believe in it so much. I have been around the legislative process for a long time now, and I can tell you, even in this legislature, you're going to hear two bills that have the same subject matter. Because somebody introduced a bill, and 3 days later, another author introduces the same bill. I know I'm being a little frank and a little forward here, but I take exception to it because I believe if you believe in this process so much, then you would have done it yourself. Or maybe you just don't like the idea of the ADUs. Well, the will of the body will bear out what the policy will end up being in the end. But I, for one, will not stop. And if I ever believe somebody else was trying to do something as a senator and basically was not doing their due diligence, I tell you what, if I believed that it was for the good of the people, I'd introduce the doggone bill myself. With that, Mr. Chairman, I look forward to the markup. I look forward to the great participation of every single one of our senators, hopefully the other 4, along with the 11 who have co-sponsored this bill, to finally bring resolution to this and to get this thing moving so we can help our people. Mr. Chairman.
Thank you, Vice Chair Dueñas. We have also written testimony submitted by Anthony R. Godwin in support of this legislation, Joy T. Dueñas in support of this legislation, and Claire Delgado also in support of this legislation. I'd like to thank everyone for being here on this morning's public hearing on Bill number 57-38. We will reconvene this afternoon at 2:00 p.m. for the appointment of Mr. Gerald Yingling. The committee will continue to accept written statements on today's hearing within 7 days from today, which may be mailed to my office on the second floor of the Guam Congress Building at 163 Chalang Satupapa in Hagåtña. You may also send your statements to us at Vice Speaker Tony Ada at guamlegislature.gov. Thank you all for your participation. The public hearing is recessed, and the time is now 11:02. Thank you, ladies and gentlemen.